Although the end of the Civil War in 1865 brought about the abolition of slavery in America, true equality remained elusive for many Americans. Discriminatory attitudes and practices were often slow to change, and so too were the laws that reflected them. Post-Civil War Nevada, which had attained statehood less than a year before Lee surrendered Appomattox, was not immune. Under the territorial laws of Nevada, non-whites had been prohibited from giving evidence against whites in criminal cases, and cohabitation and intermarriage between races was outlawed. Such exclusionary laws persisted as Nevada made the transition from territory to state. The new Constitution of 1864 allowed only white males to vote, and in 1867 the legislature required that separate schools be maintained for different races. This is not to say that discrimination was universally tolerated in early Nevada. The state had actually taken the lead in supporting the Civil Rights Act of 1866, and in 1869 Nevada was the first state to ratify the 15th Amendment, which provided that the right to vote could not be denied on the basis of race or color. Many prominent Nevadans voiced their disapproval of discriminatory legislation. One such visionary was Territorial Governor James W. Nye, a native New Yorker, who argued that such laws were behind the spirit of the age. Another eloquent advocate for equality was one of the three original justices of the Supreme Court, Justice James F. Lewis. Names like Governor Nye and Justice Lewis remain familiar to us despite the passage of time. Yet there were other Nevadans of the period who, while less prominent, made their own unique contributions to social progress. One such unsung hero was a 7-year-old boy named David Stoutmeyer. David's story began on April 10, 1871. On that day, David's father, Nelson Stoutmeyer, a laborer who owned real property but could not himself read or write, requested that the trustees of the public schools in District 1 of Orange County allow David to attend classes in that district. David met all the requirements for admission, and then some. He was a resident of the district, he was clean and neat, he was well behaved, he was also black. Nonetheless, David was looking forward to attending classes, and in his father's proud words was ready to cheerfully obey all the school rules and customs. David's excitement over attending classes was short-lived. Citing Section 50 of the Nevada School Law, which excluded blacks from public schools, the trustees unanimously denied David's application. David would not attend school with other children of his age. The news was devastating to the Stoutmeyer family. For his part, David's father was convinced that the trustees had acted illegally in denying David admission. But how could he prove it? Where could he find a lawyer who would fight for the rights of a 7-year-old boy? Would the courts even listen at all? The answer appeared unexpectedly in the form of one T.W. Davies, a native of Lynchburg, Virginia, and a true Southern gentleman. Davies, an attorney for the state of Nevada, agreed with David's father that David should be allowed to attend public school. Moreover, Davies felt strongly that the law that the trustees had used to exclude David violated both Nevada's Constitution and the federal Constitution as well. The matter was settled. Davies would initiate a lawsuit on behalf of the state to force the trustees to allow David to attend public school. Furthermore, Davies would present the matter directly to the Nevada Supreme Court. Davies argued forcefully. David's exclusion was based on skin color alone, and that, said Davies, was in clear violation of the laws of the United States and of the state of Nevada. pointing out that black Americans held office in the United States Senate and the House of Representatives and served in other positions throughout all levels of government, Davies argued that excluding them from public schools was blatantly absurd. Davies concluded by reminding the court Nevada was organized in the midst of a great war, fought for the freeing of the slaves, and for the establishment of the great doctrine that all men are free and equal, and that in that contest this state enthusiastically supported that doctrine. When oral arguments went over, he became clear that the three justices were widely separated in their approaches to the case. Justice B.C. Whitman, a Republican, agreed that David should be allowed to attend school, but was unwilling to declare that the state law in question violated the Equal Protection Clause of the federal Constitution. Instead, Justice Whitman based his conclusion more narrowly on those provisions in the Nevada Constitution allocating funding for state schools. Justice Garber, a Democrat, was unmoved. He maintained that the privilege of school admission was neither life, liberty, nor property, and therefore is not a right deserving equal protection under the laws as provided by the federal Constitution. It was clear that Justice Garber would support the school trustees. It was left to young Chief Justice James F. Lewis to cast the deciding vote. Justice Lewis's analysis began with the recognition that one of the great fundamental principles underlying our government, as indeed it must be an indispensable element of all truly Republican governments, is that every citizen is equal for the law, being entitled to all the protection which it grants to life and property. Based on this underlying principle, Justice Lewis concluded that the law in question violated the spirit of the federal Constitution. It soon became evident that Justice Lewis would vote with Justice Whitman to force the school trustees to allow David to attend school. The decision of the Nevada Supreme Court in the Stoutmeyer case marked an important advance toward equal rights in Nevada. The Supreme Court's decision was promptly followed, and David was allowed to attend public school. A year later, in 1873, the Nevada legislature repealed the entire statute, ending segregation in Nevada schools for good. Today, the words of Justice Lewis live on in the pages of the Nevada reports, and the freedoms they created continue to build and enrich our lives. Still, it's important to remember that it took more than the three justices of the Nevada Supreme Court to put the Stoutmeyer case on the books. It also took a 7-year-old boy who was determined to attend public school and in the true Nevada tradition was willing to fight for his right to do so.